This is another iRaw podcast. We podcast to make the world a better place for animals.
It's both kind and rational to like knowing animals. You can't deny it's fashionable to like knowing animals.
Hello everyone and welcome to Knowing Animals. Knowing Animals is a podcast in which we speak to animal studies scholars about a piece of their work. I'm Josh Milburn and I do like knowing animals. This episode of Knowing Animals is brought to you by the Australasian Animal Studies Association, or AASA. This is one of the leading international organisations devoted to animal studies. I'm a member and I encourage you to become a member too. Membership is very reasonably priced. The episode is also brought to you by the Animal Publics book series from Sydney University Press. And this is a collection of academic books devoted to animal studies. It covers a whole range of human animal studies, including animal law, which is the topic we're going to be talking about today. In fact, the most recent book in the series was Australian Animal Law, Context and Critique by Elizabeth Ellis. So if you're interested in animal law, I encourage you to take a look at that. Also, a quick shout out to Elizabeth Usher, who provided the updated theme tune for Knowing Animals. To learn more about Elizabeth, visit veganthews.com. Now, today we're going to be talking about a topic in which I've recently become very interested. Joining me today is Dr Marina Lostal. Marina is a senior lecturer in the School of Law at the University of Essex in the UK. A lot of her work has been around the impact of war on cultural heritage, and she's the author of International Cultural Heritage Law in Armed Conflict, which was published by Cambridge University Press in 2017. However, she's recently expanded her work to consider animals too. Today we're going to talk about her paper, De-objectifying Animals. Could they qualify as victims before the International Criminal Court, which was published open access in the Journal of International Criminal Justice in 2021. Welcome to the podcast, Marina.
Hello, thank you for having me, Josh.
Can you start by telling us what inspired you to work on this topic?
Yes, so it's a bit of a long story. I'm going to try to make it short. But it is the result or manifestation of an old calling in the literal sense of the word. As you mentioned in introduction, my initial field of specialization is the protection of cultural property in armed conflict. And that is what I did my PhD on, and I finished it in 2013. And while I was doing a postdoc in 2013, I was just chilling after a day of research, probably on cultural property and international criminal law. And I was just browsing the internet, and I came up with a video showed up of a polar bear that was struggling to survive because of the ice melting. Like he couldn't find a piece of ice to stand on and hunt. Turns out I didn't know this, a polar bear swims until exhaustion and they die. And that hit me. The internet in the world is plenty with videos of sad stories with animals, but that one, I don't know why or how it particularly hit me. And in that moment, I remember where I was sitting and where I was. I had a calling, like this is what I have to do. I have to do something to, through my field of knowledge, through my very small sphere of influence, help to improve animals' experience on this earth. And I don't know how to describe it, but maybe compare it to the experience that people who then go on to become priests or nuns, at one point in their life, they say, and then I had a calling, and then I knew, and then, that's a bit, I don't know if it was exterior or interior calling, but this is how I felt. And I still remember to this day that moment of, this is what I have to do. That was 2013, so many years ago. There were, as a postdoc, you're trying to find your place and a position that also gives us a bit of stability. So there were detours and deviations in my academic quest. But in 2019, when I was in a better place, I thought, how do I make this happen? What is animal law? How do I even start going about this? And then I met Dr Marina Candela, who's the director of the Master in Animal Law and Society at the University Autònoma of Barcelona. And she told me, why don't you do the master's? And I was like, you know what? I think that's what I'm going to do, because I needed a bit of knowledge or a structure around me to know that I was studying the right things that I had to study. And also, it was a bit like buying a subscription to the gym. Like I'm paying for the master. It's reasonably priced, but it still is a bit of money. I'm paying for the master. I'm going to do it. But so the master's has a thesis component of 30,000 words, I think it was. And then what I knew before animal law was international criminal law, international humanitarian law, and I kind of merged the two into this, what now is an article at the JCJ, Animals as Victims in the ICC.
What a fantastic story. Let me now ask a little bit about the paper itself. So we have a very interdisciplinary listenership here at Knowing Animals. So I think it'd be great if we could start with the basics. What is the International Criminal Court?
Yes, so the International Criminal Court is an international tribunal sitting in The Hague in the Netherlands that was created by state parties through the approval of a statute that we call the Rome Statute, because a conference that led to the ICC was held in Rome. The International Criminal Court has material jurisdiction over 4 types of crimes: war crimes, crimes against humanity, genocide, and aggression. And it is only concerned with individuals. It's not a court that will look into states or organizations, but individuals and their individual criminal responsibility for having committed those. Just one more thing, the ICC doesn't have universal jurisdiction. It cannot look into any crime anywhere in the world. There are certain requirements for the ICC to have and gain jurisdiction over a country. So, for example, it doesn't have jurisdiction over Russia, but it will have over Ukraine because of complicated legal rules, but just as a caveat.
So why does it matter whether animals are victims in the eyes of this court?
One of the, let's say, major developments of the International Criminal Court is the role that it gives to victims. There have been international criminal tribunals in the past, most notably the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda. These were some of the first experiments of international criminal justice after Nuremberg, after a long period of sleep of this area. But there was no role given to victims. If you were a victim, maybe you could appear in the trial as a witness, and then as a witness, you are compelled to respond to questions that are posed to you, and everything is framed around you so that only to prove the guilt of or innocence of the accused. The International Criminal Court is the first one that recognizes victims as a different entity with a different set of interests. And of course, they can also be witnesses, but they can be who they are without being witnesses. And they have the power of not being a passive or abstract voice in the courtroom. They have a legal representative that is appointed for them, and the legal representative has the power to carry the narrative of what happened to victims in the situation and context. The legal representative can make opening and closing statements. They can lead evidence. They can question witnesses from the prosecution, the defense. They can make filings, have access to the record. In essence, during the trial, they have a saying about what happened to them. And again, their job is not to prove their innocence or guilt, but to make visible the experience of victims when something horrific happened to them. When the trial is over, and if there is a conviction, then victims have another right, which is the right to receive reparations. That is, remedies to counteract or redress the harm that they suffer during the commission of the crime, or as a result of the commission of the crime. And these remedies can be rehabilitation, compensation, symbolic measures, and so forth. So in essence, they have a right to participate during trial, a right to receive reparations, and overall, they are someone, they are something in the history, or they become something in the history of international criminal law, and they have a very prominent role in the truth-telling function of the court.
What does one need to be in order to be a victim in the eyes of the court?
There are 2 types of victims: the natural persons and legal persons. And in the paper that we're discussing today, I go to examine whether animals could qualify as natural persons. For this category of victims, there are 3 requirements. First, to be a natural person. The second, to have suffered harm. And the third, to have suffered harm as a result of the commission of a crime within the jurisdiction of the court. And I go to study whether animals could satisfy these 3 cumulative requirements. But let me preface all of this exercise by saying that when I wrote this thesis and later on the article, I knew very well the answer to the question. I knew very well that the answer was no. my purpose was not the conclusion, but the analysis was to poke the bear, was to say, well, what have we thought about animals in this context before? Is it maybe time that we think about animals in this context? And this was a gateway to start doing it, because the analysis, what it does is to show the extent of suffering of animals, and that if they're not recognized as victims is only because they are biologically incapable of being human beings. The three requirements, the first one is also the one that is bound to meet more resistance, like what is to be a natural person. And I looked into what does it mean in philosophy and also in the jurisprudence of the court. And it was quite amusing to see that we kind of as a society accept that natural persons is equivalent to a human being, but there is nothing in the philosophical notion of natural person that wants to refer to the biological condition or status of being a human, but has to do with the higher moral status of persons over things. And then I thought, why are humans? Why do we have a higher moral status? And I didn't find an answer to the question. I found theories of thought that were essentially flawed, like human exceptionalism of, oh, we're exceptional, we're the best, we're great. But why is never been proven by science, actually has been disproven by science. So the red line that divides us humans from non-human animals is still to be found. Another theory of what makes a human a person, or anything a person, is the theory of social contract. If you can have duties, then you can have rights. And this is a theory that is very much espoused in international law. For example, the International Law Commission, which is an important body that helps codify and develop international law, has espoused this theory of that you're a person if you can bear duties. But this is again not explaining why this is applicable to humans, because there are humans that cannot have duties. We have infants or senile or people with disabilities, psychological disabilities, that are incapable of having duties. So why are they persons? And this led me to conclude that the bar of personhood is discretionary and a bit arbitrary, and that it depends on each legal system decision. So I looked into what does the ICC, what does the International Criminal Court think about the notion of a natural person? What do they think this means? And I found an interesting passage in the annals of the jurisprudence of the court where they had to grapple with this question for the first time. So this is a decision from 2006. So the very first days of the court that started functioning in 2002. And this might be one of the first cases where they had to understand what natural person meant. And it basically says the ordinary meaning of the term natural person, as it appears in Rule 85A, is in French un être humain tel qu'il est considéré par les droits, blah, blah, blah. And then, or in English, a human being. Full stop, and they footnote this. But then I went to the footnote that they anchor this understanding, or that they use to support this understanding. And contrary to what the passage claims, this footnote does not support the notion that natural person equals human being. It refers to Black's Law Dictionary, it's very much used and known by lawyers, which instead says, so far as legal theory is concerned, a person is any being whom the law regards as capable of rights and duties. Any being that is capable is a person, whether a human being or not.
Oh, fascinating.
And of course, this definition has its own issues, but it's quite explicit in saying it doesn't matter if you're a human being. However, fundamentally flawed at its core or not, that's the case law that exists at the ICC. And natural person, in the sense of Rule 85A, has to this day transcended to just say, well, transcended, has just been considered as meaning human beings. That is, I found, the only reason why animals cannot qualify as victims, because the other two criteria, they meet comfortably. The second one I said, suffering of harm. Can they suffer harm? Well, yes, I think they can. And they can suffer all, well, no, it's not what I think, but it's like, I think it's been proven that they can suffer harm, and of very different types. The International Criminal Court normally operates under three paradigms of harm: physical, moral, and material. And I said, well, yes, they can suffer the three of them. Physical, they possess bodies. If you mutilate a horse, you have caused physical harm to the horse. Moral harm, it's also proven that many animals possess personalities, they have memory, they react to episodes of aggression or violence by, for example, avoiding the place where it happened. So they have a memory, they have a feeling associated with that episode that denotes moral harm. And then material harm, of course, if you take their possession seriously of their habitat, for example, and you destroy their habitat, that amounts to material harm. So that was for the second requirement. And the third one is this harm in connection to crimes within the jurisdiction of the court? And then I go through a sort of kind of exhaustive examination of each one of the crimes and give evidence of how they have suffered harm in the past because of commission of crimes. For example, with the use of Agent Orange gas in Vietnam, and how monkeys and birds died with the invasion of Iraq of Kuwait, and or in the war in Yemen, how zoo animals are starving or being left abandoned in zoos. In Syria, they're also starving or being eaten. Or scorched earth operations where the method of getting at civilians is killing their cattle. So there are manifold ways in which animals suffer as a result of crimes.
It's fascinating that you say that these animals are suffering as a result of those 4 crimes that the court recognises. Because I think some people might say, well, we need more international laws, we need more conceptions of international crime in order to protect animals. But you're suggesting we've got a lot to work with already.
Oh, yes, absolutely. When it comes to victimhood, you don't need to be the object of the crime to be considered a victim. You can just be the unlucky person in the broad sense of the word that was around the crime when it happened. And if you were harmed as a result of it, even if it was not directed at you, you're a victim. You're also a victim if you are a family member of the direct victim. I would also say that there is a bit of work to do with international criminal law to recognize crimes against animals as well, like poaching, for example, or in ecocide. I would like to study to what extent they are bringing animals in the definition. So there is work to do in that respect, but there's, exactly as I said, so much that we can work on already.
And I am also interested in the way that you talk about harm explicitly, because harm seems to be an easier thing to prove than, say, rights. So you say at one point in the paper that we don't need to grant animals rights in order to recognise that they are harmed. So is there existing case law suggesting that the idea of animals being harmed is already recognised, or is this just something that you're encouraging the court to recognise?
It's absolutely correct that the pre-existence of rights is absolutely relevant for the victim status at the ICC. And this is something that distinguishes greatly the International Criminal Court and its reparation system from the reparation systems that exist in human rights courts. In human rights courts, you need a right to have been breached to move on to reparations. In the International Criminal Court, you need a conviction for reparations. After the conviction has been entered, you only need to prove harm. So your other question was, is there any case law recognizing harm to animals? Yes and no, in the sense that the crime of pillage, which has already been adjudicated at the court in the Katanga case, is a crime that was committed in 2003, involved the pillage of animals. So in order to prove that Katanga was responsible as an accessory for the crime of pillage, they had to prove that cows had been pillaged and other cattle. I don't think they were killed. I mean, at least I didn't find an indication that they were killed, but they were pillaged. So they were, if you will, harmed, but that was not relevant for reparations because there were no reparations for cows. There were reparations for the humans, for the natural persons, as the ICC understands it. And their loss of cattle was part of the harm that was considered for awarding reparations to humans. And now that I'm talking about the Katanga case, the Katanga case is the case where animals have appeared more prominently in the courtroom. First as objects of crime, but not victims. So here we can see another example of disconnect, that you don't need to be the object of a crime to be a victim, because in this case, in the reverse, a cow might have been the object of the crime, but not recognized as a victim. But then when the legal representatives of victims, the lawyers, were proposing remedies for reparations to redress the harm of victims, cattle played a very prominent role. So they propose giving cattle veterinary kits and husbandry training to the victims, to account for the pillage. But also, apparently cows are a totemic animal in the culture that was targeted in this attack, was the Hema culture. So the legal representative of victims also proposed that as a form of moral redress, persons that would have lost a significant relative, as in someone very close to them, the father, for example, they will receive a cow with 4 teeth. That's how it was put. And I think I don't know if it was approved or not, and probably still confidential, but that is what the lawyer proposed, that each person that had lost someone like a father would receive as a form of reparation a cow. Animals have never been recognized as victims or as suffering harm more than just objects, just more to prove that humans had suffered harm.
So, in section 7 of the paper, you push back against the idea that we should be conceptualizing animals as natural persons because it will lead to, and I'm quoting you here, potentially ludicrous consequences for the functioning of the court. Could you explain what you mean by that?
So, the purpose of the paper is not to advocate, and this has been misunderstood by a significant amount of people. I am not trying to say we should recognize animals as victims, so not as natural persons and therefore victims now at the ICC. I don't think it's the right moment. I don't think it's the right time. One of the reasons why I say this is because of the ludicrous consequences, which is that the term natural persons appears beyond Rule 85 of the Rules of Procedure and Evidence. For example, when the court talks about its function, it says it is to prosecute natural persons for having committed crimes. So if all of a sudden we expanded the notion of natural persons in the context of the ICC to incorporate animals, then we might be trying elephants like in medieval times. So that is why not one of the ludicrous consequences, that you cannot alter the meaning that they've given to natural persons without upsetting the function of the ICC. There are other considerations of why I don't think is the right time and the right moment. One, I think perhaps the most important is that it would be a bit incoherent to grant animals victims and reparations for being killed in wartime or in the context of these war crimes when we are killing them every day during peacetime. It would be incoherent and paradoxical that we will elevate their rights in times of war or in times of acute crisis, while during peacetime we're allowing factory farming and other brutalities against animals being perceived as normal. So I don't think the entry point of animals is this change of regime. This was an outlandish question that I was posing to allow myself to do this analysis and to mainstream the animal question in international criminal law circles.
Yes, so instead, your conclusion is that we need to change the view of animals in the international community before we change the definitions in the International Criminal Court. So this is a difficult question, but are you optimistic about the prospects of a change in the view of animals in the international community?
Oh, yes, absolutely. For different reasons, I've been reading in the past 2 months two different books, nothing to do with the other. One is fiction, one was about prehistory, written in 1920. And I was amazed at how some things were referred to. I was amazed at how society was, and it was depicted in, for example, the fiction book. Things that would be unthinkable today, and probably the other way around. In 1920, when the fiction book was written, if they had given the author a glimpse of how society is now, he would have probably fainted and died on the spot. So I think change is happening in the newer generations, in systems of thought, in this scholarship even being taken seriously. There's going to be, of course, a lot of pushback coming from different directions, but there is a very clear direction of discovery of what it is to be an animal, what is an animal experience, and how do we need to treat animals. That I think is unstoppable.
What a great note to end on. Now, Marina, we ask every guest on Knowing Animals 5 quick questions. Are you ready for your 5 quick questions?
Yeah, I'm not sure it's going to be quick answers, but go ahead.
Can you recall the first piece of pro-animal scholarship you ever read?
Yes, that I recall very well. So in 2013, after I had this calling, I didn't know from where to start. And I think I went to an online website to buy a book. And I bought the first one I saw, and it was fantastic. And it was Lori Gruen, Ethics and Animals.
Can you recall the first piece of pro-animal scholarship you ever wrote?
So the thesis for the master, which was a very much extended version of the article, a 30,000 piece, by the way, that I have to say was supervised by Professor Ann Peters.
If you had to name one animal studies scholar who's had a big impact on you, who would it be?
So that would be Professor Ann Peters. And I would not say that just because she was my supervisor, and a great supervisor, I have to say, way before I couldn't believe my luck when she accepted being my supervisor, because I looked for her. And the reason is because Ann Peters put the animal question in international law. When in 2013 I had this calling, I didn't even know what this meant and how could I go about doing this as someone who had been trained in international law. And Ann Peters mapped out how international law and international lawyers can have a say in the quest to improve animal lives. She opened the path to think, and many of us are following this path in discrete routes under her school of thought. And one more thing about why I think she's crucial is because Professor Ann Peters, when she started doing animal law, she was already a very well-established academic with a renowned reputation on different matters in international law and constitutional law. And all of a sudden, she turned and said, hey, what about animals? So she's the living proof that animal law is a serious matter that deserves lawyers' attention.
What do you think is the most important thing that academics can do for animals?
So I don't know anyone in academia that has gone into this field of work because of money, right? So that's not the goal. I think the goal is knowledge, justice, if you will. And so I think that what we should do is keep building knowledge and help critique and dismantle systems of thought that are rooted in wrong or unfair assumptions, and move the signpost for animals a bit further away with each research that we do.
And if you had the power to change one thing about the human-non-human animal relationship, what would it be?
So many listeners might have noticed in my accent, I'm from Spain. So I'm going to say bullfighting. There is Article 13 of the Treaty of the Function of the European Union that recognizes animal sentience. And so members of the European Union need to take this into account when proposing policies. But there is a qualifier to this rule, which has to be in respect with religious and cultural practices. And I read that this qualifier was introduced by the Spanish Ministry of something back in the day to protect bullfighting. And I was like, what Spain is this? What culture? I was raised in Spain. I've lived there for a fair amount of years. I think I've met two persons in my life who, of all the Spanish people that have been around, who liked bullfighting. And the second one was recently, and the conversation I had with her was revealing as well, because she was a former teacher of mine, now retired, and I tracked her down because she had a very positive impact on my life, and I wanted to see her. So she asked me, what are you doing? And I told her, I'm doing research on animal law. And then she was like, but you wouldn't try to ban bullfighting, will you? That was her first reaction. I was like, well, I wish I could, but I was like, I would have never imagined that you like bullfighting. She was a nun on top of everything. And she was like, well, I don't like the part where they kill the bull. I like the party around it. And then again, it made me think, what is the cultural, whose cultural practice is this? So if I could do something to ban bullfighting, I would.
What is it you're working on next?
I am working in a project, we're trying to look into the lack of regulation of hunting in the UK and how that has implications for sustainability and welfare.
Oh, that's fantastic. I really look forward to seeing what you come up with. How can people find out more about your work?
I'm not very active on social media, but they can find me on Essex University, my profile. I do have a LinkedIn page and they can follow me there. I sometimes put some updates about my work there.
Well, thanks so much, Marina, for joining us for this podcast.
Thank you very much for having me.
And thank you, listeners, for joining us for Knowing Animals, the podcast where we talk to animal studies scholars about their work. You can follow us on Twitter at knowing_animals or on Facebook at Knowing Animals. You can also follow me on Twitter at Josh L. Milburn or on Instagram at A Vegan Philosopher. Please do spread the word about Knowing Animals, include it on reading lists if you're a teacher, review the podcast online, put it on social media. We are keen to reach new audiences. I'm Josh Milburn, and I do like knowing animals.
For more great iRaw podcasts, visit irawpod.com. That's IROARPOD.com.